from the main list. Item number 1.
Yes, where are we?
Please, Lordship.
Yes.
Lordship, the serious difficulties, my lord. There are serious difficulties in the matter, my lord. My lord, the way I thought it will work out, my lord, is not working out that way, my lord. I was under the impression that if I communicate the desire of your lordship, my lord, to the ministry and CISF, now they have come up with a plea that that the deployment policy of CISF does not suit this particular job, my lord. But they have not given me an answer that which other force, my lord, will be the right.
Because we had asked for CRPF.
My lord.
We had asked for CRPF.
My lord.
Anyone would do it, diligently.
My lord.
You had suggested,
my lord,
CISF.
My lord, I was told.
At the end of the day,
my lord,
we have not issued any direction yet.
My lord.
We are just exploring.
My lord.
And we really don't care too much for them not willing. If we direct,
my lord,
they and their bosses will have to fall in line.
My lord, that is
unless they get it,
my lord,
and I'll buy a superior forum, which is there. It's their choice.
My lord.
So we are not there with a begging bowl asking them. We will ultimately direct them.
My lord.
And they better fall in line.
My lord, my lord.
Right? So
but what I would pray, my lord, if a direction is issued to the ministry, my lord, that whichever is the right force for this kind of duty, my lord, and to act accordingly, my lord.
And what is the progress on the sale, Mr. Khan? You are appearing for the state.
Lordship, yes. Lordship, so far sale is concerned, Lordship, it is progressing, but right now.
No. We want the exact thing. The last order.
As per the direction of the court, Lordship, it is progressing.
Last order was on 20th March.
20th March. March was basically regarding CIFS and proposed weighbridge, Lordship. So far 23 is concerned, Lordship. 19 is in operation, weighbridge.
That should have been done 31st March 23, and we said that augment that. Plus, yesterday you said at your instance we recorded that there is now a system in place.
Lordship,
and look what happened in River yesterday.
Lordship, I'll just give you a copy of my instruction.
Yes, but if your instructions are false,
no, Lordship, no.
Then who is accountable?
No, Lordship, the accountability we are giving. Notification on this.
Your instructions were belied by an accident last evening.
It was very unfortunate, Lordship, yes. What the observation is? 3 so. Even security. This camera is Lordship, can I access the court?
We also have rules, Mr. We also have rules. We have, many laws. We have guidelines. But just having the rules on paper is not enough.
Can you allow me to persuade this court on a very important matter? Lordship, let me just pick up the argument from yesterday from where I left. There was an FIR filed by the Superintendent of Taxes, Assam, regarding the illegality. Why that argument is very important for today's continuation is that the FIR was filed. Finally, whatever was happening, the criminal law was set into motion and FIR was filed. The veracity of the documents are yet to be tested by either charge sheet or non-charge sheet. And it is slightly unfortunate, Your Lordship, the counsel for Respondent 14 did not bring to the notice that the very FIR was challenged in the High Court and there has been a stay. So that is not progressing. Which my purpose of saying is this: the whole issue of illegality has to be tested in the anvil of a criminal law being set into the motion.
No, we don't care for that.
Lordship,
We don't care for that really.
Most probably, Lordship is correct. But tentatively, Your Lordship, so far state is concerned, Your Lordship, our hands are tied, Your Lordship, insofar as whether rules are in place or not.
Your hands are not tied. You are duty bound
Lordship.
to ensure that the orders passed by the Supreme Court, you don't care for the High Court, all right. That's all right.
That is not the case.
We accept that. You don't care for the High Court, we accept that. That's fine. But, there's a constitutional provision
Absolutely, Lordship.
that you have to adhere to the orders passed by the Supreme Court,
Absolutely.
and every person has to do that.
Absolutely, Lordship.
Now, if you don't do that, that's an affront to the Constitution.
Absolutely correct.
An affront to the Constitution amounts to, very high offence.
Absolutely correct, Lordship.
Now, there it says ban illegal mining. Empirically, we have seen that there is no ban. There is no effective ban. The one way of controlling it is stop transportation. It will pile up. There will be no demand. That will effectively stop it. You have not done it. Now, when any ordinary person would suspect that when such large amount of coal is suddenly being exported, it wasn't as if it was a continuous process.
Absolutely correct, Lordship.
A request suddenly came in April of 2021, and for a long period, a huge quantity of coal was exported. Now, it's your business to ascertain what is the origin of the coal.
Absolutely, Lordship.
You have only seen X says I bought it from Y. But what is the origin of the coal?
Absolutely correct.
In the light of illegal mining happening in your state, illegal transportation happening in your state, how can you rely on a document which says X says I bought it from Y? Ordinary prudence, and you're a state government, you're not, some toddler. Ordinary prudence would demand that you find out where did Y get it from. The moment you inquired, you would have found out this circuitous transaction going on between XYZ.
Absolutely.
And you had counsel yesterday trying to give evidence that they're bought from open market in Assam, which does not find place in his affidavit.
Very unfortunate, Lordship, yes. At least he did not mention that fact also in the affidavit and making an oral statement. That was very unfortunate.
So in this situation, if we think that you are conniving or actively encouraging or complicit, are we very wrong?
Absolutely not. Lordship, can I just, what Lordship is what is fallen from the Lordship, we can't deny it because committee headed by Justice Kakati is already in seize of the matter and there is nothing much for us to say or deny it. Lordship, the only limited query that I just like to place before the court, Lordship. Lordship, we just take a notification of 26 July 2022. The first notification, Lordship. Lordship, the date is very important.
Yes.
Lordship, when I said yesterday, when I submitted, Lordship, the system is in place. Lordship, kindly note the date, 26 July 2022. What has fallen from Lordship today and what has been falling from the Lordships for last more than 7 months is very correct. So far the pre 26 July 2022 situation is concerned. So after 2026
This is only a special court for trying these cases.
Lordship, the mandate of 30B, the Mines and Minerals Development Regulation Act 1957, 30B contemplates that a special court, Lordship will see the court has been constituted, and the power, Your Lordship, power is very important. The concerned district and session judge of all districts. The power is not given to ordinary magistrate. And Your Lordship, 30B clearly says the penalty is maximum for 5 years, and for per hectare it is 5 lakh penalties. Now, Lordship, after 26 July, when I said system is in place, Your Lordship, and why I am relying on this rule of 24 March 2022, the next page, Your Lordship, 23C.
Yes.
It's an act by the Parliament. It will not be enforceable in a state of Meghalaya until unless we frame a rule. Lordship is very aware that non-starter of this particular 23C was all the source of problem. Because we have to identify the competent authority who is going to seize the matter in case of illegal transportation. And Lordship will kindly see the notification is of 24th March 2022. The charging section is 23C. We had not set into the motion before 24th March 2022. And Lordship will kindly see what is the rules, the heading of the rules. Meghalaya Minerals Prevention of Illegal Mining and Transportation. It exactly addresses the issue. 23C takes care of this. The issue is illegal.
So you frame the rules, you frame it, and you put it up on the wall. Where is the implementation of it?
Lordship will come to page 28 of my affidavit. Which one, sir? There, page 28.
I've given you.
Lordship, affidavit dated 1/3/2022.
Yes.
If I may take you to page. Lordship, I can take your Lordship to page 27, para 20. It is submitted that the reports was called from all deputy commissioners of state to inform the action taken by them for controlling illegal mining in the respective district. The district-wise summary of the action taken by deputy commissioners are here below, Your Lordship. First is officer in charge of all the police station have been instructed to check illegal mining and take necessary steps against the violator. Lordship, I am not going to this part because Lordship will say this is only the
Yes, what is how many trucks have been seized? How many tons of coal have been seized?
Lordship will just come to B, page 28. Joint patrolling team consists of executive magistrate, divisional mining officer and transport has been constituted to check illegal transportation of coal. The district level forces have been constituted to check illegal mining. And transport of minor minerals and 20 cases has been registered against during mining of 2021.
Minor mineral?
But Lordship, yes.
Minor mineral is not coal.
Lordship, so far
Coal is not a minor mineral.
Absolutely correct, Lordship. So far...
Tell us, how many tons of coal and how many trucks have you confiscated?
Lordship, if you come just to page 29 again, in continuation, District Mobile Squad has constituted to check illegal transportation of minerals and illegal mining activities. Total 43 cases have been registered under section 21 of the MMDR Act 1957 against illegal transportation, mining of boulders and limestone.
Where is coal?
That is it, Lordship. So far, where Jayanti is concerned, we agree, Lordship, it's regarding limestone and miners. But Para C, Lordship, is Jayanti district.
24th March, Mr. Khan, if you remember, would have been immediately after we took cognizance of the matter. I suppose on 4th or 5th March, we took up the matter. We took your chief secretary along for a tour. All of us went. We did not utter a word. Your chief secretary couldn't look down the valley because what was happening was daylight robbery over there. All right? So,
Lordship, so far coal is
issued after that. We would like to know how many. Yesterday there was a truck which fell into the gorge.
Lordship, absolutely.
Now, how many trucks and how many tons of coal have you arrested after that?
So far, Lordship, page 29, Para C, East Jayanti is concerned. We have answered that specifically on coal, Lordship. District level task force has been constituted to check illegal mining and
task force is considered. We've also constituted several of those things. Where is the action?
Lordship, 12 number of cases are registered against illegal coal transportation and 2 cases against illegal coal mining in the year 2022-21. More than 50 number of mining raids conducted so and so period.
Does it not give power to seize the truck or the coal?
It does, Lordship. Under the provision...
When have you said that you've seized coal or truck?
Lordship, in the affidavit, yes, I made a Lordship. We have not said this, but part of the seizing a Lordship,
Because there is none.
Lordship, the consequences of registering a case and seizing will include seizure of truck, seizing the mine.
Well, you file an affidavit and tell us how many trucks have you seized, how much coal have you seized. We'll wait for that.
Lordship will come.
Pursuant to the order dated March 20, 2023, this matter was directed to appear today for Dr. Muzika, learned DSGI to indicate how soon the Central Industrial Security Force could deploy 10 companies for the purpose of checking the illegal transportation of coal in the state. Full stop. Paragraph. Dr. Muzika reports that the CISF is unwilling to undertake the work, primarily because it does not fall within the usual activities undertaken by such police force. Full stop. It needs to be recorded here that the court did not seek out CISF in particular, but the court had initially sought to explore the possibility of deploying the Central Reserve Police Force with the mandate to check the illegal transportation of coal in the state. Full stop. It was at such stage that it was suggested on behalf of the union that since the CRPF would work under the instructions of the local police and the real intention of this court was for the local police not to be associated in the process since it had been ineffective in such regard till date, it was suggested by the union that the CISF may be the appropriate force. Full stop. Paragraph. In any event, no direction had been issued for deployment. Full stop. The previous orders merely provided for the CISF to indicate its readiness. Full stop. Paragraph. Despite the unwillingness on the part of the CISF, once a direction is issued by the court, the relevant force will be bound thereby, subject to its right to have the order corrected in the appropriate forum. Full stop. However, no such direction is issued immediately, and the Union Ministry of Home, through the Home Secretary, is directed to ensure the deployment of 10 companies of appropriate Central Police Force to be commanded independently or jointly by officers that may be officers from the local police that may be selected by the court, strictly for the purpose of keeping a vigil on the roads and arresting the illegal transportation of illegally mined coal in the state. Full stop. The paragraph the union's response to the relevant secretary should be available when the matter appears next, a fortnight hence, full stop. It must be a paragraph. It must be appreciated that there is an unusual situation which has arisen, full stop. Despite orders of the Supreme Court, which have been in place since about 2016, rampant illegal mining of coal has continued in the state, and such illegally mined coal has been allowed to be freely transported, even to the extent of being regularly exported to Bangladesh by possible false declarations that the coal originated elsewhere. Full stop. Paragraph. Since the local police force, under the state government, has been completely ineffective or unwilling to control the menace or implement the orders of the Supreme Court, which they are duty bound so to do, it is felt appropriate that an external police force, may be deployed for checking the illegal transportation of illegally mined coal in the state. Full stop. Paragraph. Meanwhile, Justice Kataki has filed a 12th interim report. Full stop. Most of such report deals with the manner in which the previously mined coal is to be auctioned. Full stop. Previous orders have recorded a timeline for completion of the process. Full stop. It is imperative that such timelines are adhered to, since freshly mined coal is being sought to be passed off as previously illegally mined coal in the state. Full stop. Paragraph. Let copies of the 12th interim report be circulated by the officer of this court to the state, the union, Coal India Limited or Coal Controller, Coal India Limited, and any other interested to obtain copies, and any other party interested to obtain copies thereof. Full stop. The matter will appear a fortnight hence. No, just before that. Let a further ad hoc remuneration of rupees 3 lakh be paid to Justice Kataki. Full stop. The matter will appear a fortnight hence. Paragraph. It is recorded that the state has relied on a notification of March 24, 2022, by which the Meghalaya Mineral (Prevention of Illegal Mining, Transportation and Storage) Rules 2022 have been brought into effect. Full stop. A further notification of July 26, 2022 has also been placed. Full stop. Under such by such notification, in exercise of the powers conferred under Section 30 capital B of the Mines and Minerals Development and Regulation Act 1957, the state government has constituted special courts in districts for the purpose of speedy trial of offences for contravention of the provisions of subsection 1 or subsection 1 capital A of section 4 of the Act of 1957. Full stop. The submission on behalf of the state is that upon the issuance of such notifications, the state has done all within its power to check or stop the illegal mining of coal. Full stop. Paragraph. However, notwithstanding this court recording the state submission, at the insistence of learned additional advocate general, that there was now a system in place which completely stopped the illegal transportation of coal, an accident has been reported in today's newspapers of a truck illegally transporting illegally mined coal in Riboy district. Full stop. There is no doubt that both illegal mining and illegal transportation of coal continues, and if the rule of law is to be asserted in this state, it cannot be done with the present machinery available in the state. Full stop. Paragraph. Then finally put that, let the matter appear a fortnight hence. Nothing personal, Mr. Khan, but this is something, this is our duty.
Absolutely.
This is our duty. We have to be unpleasant when we have to.
The first time that what is on record, these rules will get come up since 22.
What he's trying to say actually is that you have not, your special courts have not taken anything, so it's your fault, not our fault.
No, Lordship, if I just take
That's what he's trying to say, but
Lordship,
you have to digest that and see what is there. We are fairly audible, I suppose.
Absolutely. Lordship, at least we are complying with Article 21,
Yes.
the rules of law at least.
Yes.
And Lordship, in page, if I may just summarize, Lordship, the requirement under 22 is that there has to be a competent authority. Who is going to file? And Lordship, if I just take to page 51, for a minute, Lordship.
I wish there was a notification by which you would appoint our district judges to check. Then there would be effective checking.
But Lordship, if Lordship, for a moment, if I take to page 51, the next year, 13 March 2019, under the MMDR Act, the complainant cannot be anybody, it has to be an authorized person from the government. Same goes. That also we have affected in 13 March 2019.
We have not recorded that your affidavit that you read out,
Lordship, yes.
which talks only of boulders.
Only, there's a whisper of coal, Lordship, is giant hills, Lordship, we admit.
Just find out if there's any. They are falling into gorges, but they are not falling into your lap.
We're making all efforts, Lordship.
Yes, we understand.
At least with the law in place and with the complainant in place and with the power given to district judge. So the matter is serious, Lordship.
Very well. Fortnight. Give a particular date.
Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1.
Lordship, just regarding the probate matter which is pending in Calcutta High Court, Lordship, the hearing is concluded in that matter. The hearing is concluded.
Oh, hearing is concluded. Before whom?
Before Justice Arindam Mukherjee.
Oh,
Now
very
the
good.
judgment is reserved, Lordship.
Very good. Since the petitioner says that now this matter has waited for a considerable period of time because a connected matter was pending before the Calcutta High Court. Full stop. The petitioner submits that the relevant petition for revocation of probate has been heard out by the Calcutta High Court and judgment is awaited. Full stop. Accordingly, let this matter appear 3 weeks hence.
Lordship,
If the judgment does not come, we'll give you some more time.
Lordship.
Or 4 weeks hence.
Obligation.
Item number 2.
If it is, please, my Lord.
Yes. What is the matter?
This is the statutory appeal, my Lord. My Lord, seal number 2, 3, 4 are connected, my Lord. For the convenience, my Lord, I'll be taking seal number 4, which is the lead matter, my Lord. My Lord, these are the statutory appeals arising.
The papers of number 4.
Arising from the judgment passed by Honorable Sestat, my Lord.
And the 4 appeals pertain to 4 different financial years.
No, my Lord. Seal number 4 pertains to the appeal of the company. Serial number 2 and 3 are of the individual directors, my Lord, with respect to personal penalty,
Very.
arising out of the same impugned orders.
Transactions.
Indeed, my Lord.
Yes.
My Lord, before that, my Lord, before this matter was heard by my Lords, and after hearing, the matter was remanded back to the Honorable Tribunal to decide on specific 3 issues, my Lord. One was with respect to invocation of extended period of limitation. Second was with respect to brand name. And third was with respect to turnover, my Lord. From the impugned order, my Lord, if I'm...
This is a biscuit matter.
my Lord, soya bari matter.
Soybean, yes.
Soya bari matter. So my humble submission today before my Lords is that the directions given by my Lord have not been complied with by the Honorable Tribunal. So I'll just demonstrate that, my Lord. So, my Lord, before that, if I may be allowed to take to my Lord's own order, my Lord, at Annexure 14, page 260, my Lord. So as to just show what were the directions and whether the same have been complied with or not.
Page 260,
my Lord.
60.
60, yes. Should I read, my Lord?
Yes.
So, my Lord, starting from next page, my Lord, 261. Para 2 enumerates the facts, my Lord. Para 2 and 3 enumerates facts, my Lord. And then starting from para 5, my Lord, if I may be allowed to read. The first issue that arises is to whether such demand could have been made at all, particularly in respect of the period more than a year prior to the date of demand, As noticed in the previous order, ordinarily a demand may be made to realize the duty for a period of 1 year from the date that the duty became payable, but an exception is carved out for a demand to be made for an earlier period if it is demonstrated by the department that the manufacturer intended to evade the duty. Para 6, my lord. Accordingly, the appellant, since the appellant was entitled to an exemption in the sense that it would be reimbursed the excise duty that it had paid in view of the existing central excise notification, the question of intending to evade duty could not have arisen, since the appellant would have been reimbursed the excise duty paid for the relevant product. On behalf of the department, it is submitted that it may not be absolutely correct to say that the entire quantum of the excise duty would be reimbursed to the manufacturer and the scheme was modified from time to time. According to the department, the excise duty component would be reimbursed upon deducting the SENVET credit already claimed. The department also says that at a subsequent stage, the extent of exemption granted was that the amount reimbursed would be only to the extent of excise duty on the value added to the product in the course of the manufacture. Moreover, more importantly, the department points out that not every manufacturer in Meghalaya would be entitled to the exemption by way of reimbursement or otherwise. In such context, several notifications published by central excise authorities have been relied upon to demonstrate that the initial scheme was restricted to certain areas of Assam and Tripura, and later designated places in Meghalaya were also included. According to the department, the manufacturing unit of the appellant is not located within any area designated by the applicable notification for the applicant to claim exemption by way of reimbursement. Para 8, my lord. This aspect of the matter was not taken into consideration, whether in the course of order in original being passed or in the appellate order of the tribunal. This is a question of fact on which there can be no two opinions, and a physical verification is necessary to ascertain whether the manufacturing unit of the appellant falls within the area designated in the applicable notification for the appellant to be entitled to exemption by way of reimbursement. So, my lord, this was the issue with respect to invocation of extended period, my lord. Now, the specific direction was to verify physically whether my unit is located within the designated area or not, my lord. I'll take, my lord, to the relevant paragraph of the impugned order wherein this issue has been dealt with. But before that, my lord, just few paragraphs of this impugned order to show what were the direction, my lord. Second direction was with respect to the brand name, my lord, which is the subsequent paragraph, para 9. The second aspect of the matter on which there is no discussion in the order of the appellate tribunal pertains to the disqualification of the appellant to be entitled to exemption on the ground that the appellant manufactured the product under the brand name of another. According to the appellant, it started manufacturing of soya chunks under the Gulab brand name with effect from December 1, 2006. The appellate tribunal has referred to the oral evidence of a regular customer of the appellant, which appears to be a rather sweeping statement to the effect that appellant has always been engaged in manufacturing soya chunk under the Gulab brand. The appellate tribunal placed great credence on such statement, though there were no document in support of the assertion, nor any bill or voucher or the like relied upon by the department that would reveal that appellant had manufactured soya chunks under the Gulab brand prior to December 1, 2006. The appellate tribunal also referred to statements of two Sharma directors of the appellant, but such statements do not reveal the manufacture of Gulab brand by appellant prior to December 1, 2006. When, para 10, when a person claims a benefit under any government scheme and the authorities seek to deny the eligibility of such person to obtain such benefit, the onus is on authorities to demonstrate why a person would not be entitled to the benefit. As noticed above, it has been to the consistent stand of the appellant that it did not manufacture the Gulab brand soya chunks prior to December 1, 2006. It was thus incumbent on the department to deny the appellant exemption for the period prior to December 1, 2016 only upon cogent material being produced in such regard, whether by way of bills or vouchers or unimpeachable statement, unimpeachable statements or otherwise. This was the second issue, my lord. Third issue was with respect to the turnover, my lord, which is para 11. Third issue that requires to be looked into and answered is related to the appellant being entitled to the exemption or not. The wording of the applicable notification exempts a manufacturing unit as an SSI till such time it attains a turnover of 1 crore. In the present case, the initial turnover in 2003 and 4 was extremely low and same picked up only in 2004-5. In the event the appellant was entitled to exemption as claimed, it requires to be ascertained when the appellant's manufacturing unit exceeded the turnover of 1 crore for the excise duty to be claimed only thereafter. Then my lord, basis these three, my lord, then my lord directed that the three key aspects of the matter have not been addressed in the order of the appellate tribunal in the appeal arising out of order in original dated so and so. These issues cannot be conveniently addressed in the present proceedings, which are conducted on summary basis on affidavit evidence. Further, as to whether a person is entitled to an exemption or not based on geographical location of the manufacturing unit is essentially a question of fact that has to be ascertained. Accordingly, the order impugned dated so and so is set aside and matter is remanded to the appellate tribunal with a request to render the opinion on three key aspects indicated herein and on any other issues that may be relevant for the purpose of adjudication. The tribunal is also requested to pass its reasoned order within 3 months from the receipt of authenticated copy. So, my lord, these were the three issues basis which directions were given to the Honorable Tribunal, my lord. Now, my lord, if I may be allowed to take my lords to the impugned order, my lord. It starts annexure 15, my lord, page 265. I'm sorry, my lord. So, my lord, with respect to the first direction on extended period, my lord, I may straight away take my lord to para 4.11, my lord.
So what are the three issues?
My lord, one is invocation of extended period under section 11A of Central Excise Act, my lord.
Section 11 is the extended period of
Indeed. So, my lord, initially it provides for a normal period of 1 year.
intention to evade.
If there is intention to evade, extended period of 5 years can be invoked, my lord.
Then the next aspect is?
My lord, the second aspect is with respect to the brand name under which the product is being manufactured, my lord. Now, the implication of brand name is, my lord, if I am held to be using a brand name for manufacturing a product, I will not be entitled to claim small scale industries exemption, my lord. Even if my turnover is, let's say, less than 1 crore, which is the threshold, my lord, if I'm manufacturing the product
For somebody else.
for myself or for somebody else, but if it is a branded product, I will not be entitled to claim SSI exemption, my lord, which is my claim. So that is the second issue, my lord. Third issue is with respect to the turnover, so as to when my turnover exceeded the threshold, which is 1 crore. Because, my lord, if in the preceding year my threshold was less than 1 crore, I'll be entitled to claim SSI exemption. Let's say in the current financial year, in the month of, let's say, July, I exceeded the threshold of 1 crore. So for this period, I'll be entitled to the SSI exemption with respect to the turnover of 1 crore. So let's say if my turnover in this year is 4 crore, I'll be taxed only on 3 crore. So this is the relevance of these two issues, my lord.
Where is the discussion?
Indeed. My lord, as far as extended period is concerned, my lord, it starts at para 4.11.
We'll ask Mr. Just wait. Dr. Mosika, show us these three answered, dealt with and answered.
My lord, at page 299, my lord. para 4.9, my lord.
299.
Page 299, para 4.9, my lord.
4.9.
Towards the bottom, my lord, page 299.
Thus, we conclude that the first issue,
That is in respect of denial of the benefit of SSI exemption for the reasons that appellant 1 was manufacturing and clearing the goods under the brand name Gulab brand, the impugned order cannot be faulted with. Then it says, my lord, since the benefit of SSI exemption cannot be extended to the appellant for the reason stated in para 4.9, the question as to when they have crossed the exempted turnover limit of rupees 1 crore is of no significance from the turnover as recorded in the para 4.6 above as per para 9 of the so-called notice. And as per annexure 8 of the so-called notice, appellant's value of clearance during each year was much higher than rupees 1 crore.
My lord, with due respect, my lord, if I may be allowed to bring to my lord's notice para 4.7 at page number 295, my lord, where the reasoning is given by the Honorable Tribunal, my lord, on this particular aspect. Page 295, my lord, para 4.7. Should I read, my lord?
And my lord, the third issue is addressed in page 305, my lord.
My lord, the specific direction was to come up with corroborative material evidence. Again, my lord, para 4.7, the Honorable Tribunal has simply relied on the statement, my lord, and simply says that there are such circumstantial evidences. Where are those substantial circumstantial evidences, my lord? If I may be allowed to read, my lord, from the para 4.7, my lord, page 295. From the facts as recorded in the show cause notice and adjudication order, it is quite evident that the benefit of SSI exemption has been denied to the appellant not only for the reason that they were clearing the goods under the brand name Gulab brand, but also for the reason that they had crossed the exemption in the year 2003-4. Further, it is quite evident that the appellant 1 is a private limited company and the brand name used for the clearance of the said goods is registered in the name of partnership firm, wherein the 2 directors of the said unit are partners. The brand name is registered in the name of partnership firm Messrs. Vinita Soya Products since 10th October 1994. In fact, this fact itself is enough to hold that the appellant 1 was clearing the goods under the brand name of Gulab brand. However, Revenue has further adduced evidences by making the market inquiries and recording the evidences in the form of statement of directors of the appellant 1 and purchaser of the goods. It is not just the statement but also circumstantial evidences which have been taken into account by the adjudicating authority for concluding that the appellant 1 had cleared the goods contrary to the provisions of the SSI exemption notification. Appellant has not produced. Now the Honorable Tribunal has shifted the onus on me, saying that appellant has not produced any evidence either before the adjudicating authority or before us to establish to the contrary. So, my lord, here also, my lord, they clearly rely upon the statement of the purchaser, my lord. Basis that they say that I was using a brand name. In fact, my lord, the statement which they are relying upon, all these statements are not conclusive, my lord, wherein the statement clearly says that I was in effect using a brand for manufacturing my product, my lord. In fact, my submission is, my lord, I started manufacturing branded product after 1st of December 2006, my lord, and after that I'm not claiming SSI exemption, my lord. So, my lord, when I received no objection certificate from the concerned partnership firm to use the concerned brand Gulab, my lord, after that I started using the brand name, my lord. So before that there is no evidence adduced by the department to show that I was using Gulab brand prior to 1st of December 2006, my lord. So, my lord, this is with respect to the brand name, my lord. As far as extended period is concerned, my lord, the
Yes.
the finding with respect to invocation of extended period starts at page 300, my lord, of the impugned order, para 4.11, my lord. If I may be allowed to read, my lord. Page 300, my lord. Should I read, my lord? Para 4.11, my lord. My lord, now coming to the issue of limitation for making the demand, appellant have contended that they did not have any intention to evade the payment of duty. The crux of their submission is that whatsoever duty they would have paid would be admissible to them in the form of cash refund as per notification number 32/1999, which is applicable to them, and the entire exercise is thus revenue neutral. They also submitted that they were under bona fide belief that their goods manufactured and cleared by them were correctly classifiable under heading 3204 and attracted nil rate of duty. My lord, then the table is reproduced, my lord, with respect to the applicable rate with respect to different timelines, my lord. And then, my lord, the cases on which we were relying upon. Then, my lord, page 304, bottom, my lord, para 4.13. My lord, page 304, para 4.13, if I may be allowed to read, my lord. Now we take for consideration the above argument. Commissioner has, in the impugned order in para 3.7, considered the issue of limitation and have concluded that extended period of limitation can be invoked for making this demand. Appellant's contention is that they were under the bona fide belief that their goods manufactured by them were classifiable under 2304 and attracted nil rate of duty till the issuance of notification number 3/2006 classifying the said goods under 21061000, attracting the duty at the rate of 8%. They relied on the certificate dated 13th September 2006. So, my lord, here I have submitted a certificate issued by the department itself, wherein they clearly say that my product is not excisable. I am not required to take excise registration because the applicable rate of excise duty is nil. My lord, basis this, my lord, and this certificate was issued to me on my request, where I was inquiring whether my product are excisable or not, whether I'm required to take registration or not. That was in the light of notification number 3 of 2006, my lord, dated 1st of January 2006. And on 13th September 2006, department clearly says, my lord, that my product is nil rated. I'm not required to take registration, my lord, central excise registration. And, my lord, after reproducing the certificate, my lord, if I may be allowed to read, the certificate says, this is to certify that Vansa Fragrance, address so and so, who manufactures soya nugget, in bracket, my lord, soya chunk, falling under central excise tariff heading 2304, as per their declaration, is not a registered central excise factory, as the product attracts nil rate of central excise duty as per tariff, and as such is not required to obtain central excise registration. After this, my lord, the observation of the Honorable Tribunal is that Commissioner has considered this certificate and has recorded his finding on the said certificate. It is interesting to note that Appellant 1 has approached the Range Superintendent via his letter dated 23rd August 2006 seeking clarification in respect of dutiability of their product, whereas it is their claim that their product became dutiable from 1st of March 2006, when notification number 3 of 2006 dated 1st of March 2006 was issued. It is their submission that they had voluntarily approached the department for payment of duty from 1st of March 2006. What was the purpose for approaching the range superintendent on 23rd August 2006, when, in the understanding of the appellant, the product was subjected to duty from 1st of March 2006. Further, it is observed that the notification number 3 of 2006 has been issued under Section 5 of Central Excise Act, which empowers the government to grant exemption of duty leviable, which is excess of the rate specified in the notification. It is also interesting to note that appellant never approached the department seeking any clarification in respect to dutiability of their product, though they had commenced commercial production and clearance of their factory in the month of March 2003. Obviously, the fact in respect of production and clearance of goods were never disclosed to the department till 23rd August 2006, and appellants had suppressed the same from the department. Para 4.14, my lord. Appellants claim that they would be eligible for benefit of notification number 32 of 1999 applicable to the units located in specified area in the northeastern states. Appellant never made such claim before any authority, including the tribunal. In first round of litigation, the claim to this exemption notification has been made by the appellant before Honorable High Court. So, my lord, in fact, this finding is not with respect to direction given by my lords, my lord. The direction with respect to invocation of extended period was to see whether my unit is physically available or located in the designated area or not, my lord. In fact, my lord, the observation which the Honorable Tribunal has made, that is factually incorrect, my lord. Why? Because before the Honorable Tribunal, I raised this very point with respect to area-based exemption notification, my lord. The same is recorded at page number 259 of the appeal paperwork, my lord, which is the order of the Honorable Tribunal, my lord. The first order of the Honorable Tribunal, my lord. In fact, my lord, after submitting that none of these directions were complied with by the Honorable Tribunal, my submission is that the invocation, the extended period of limitation is not invocable in my case. There are 4 or 5 submissions to that effect, my lord.
Yes.
So, my lord, the first submission is, my lord, that
There
the
does
word
not appear to be any discussion on any of the aspects.
Lord, if I may submit.
We don't want to send it back repeatedly, but then it's like we'll have to take it up.
But in my humble submission, there are basically 3 issues.
Because there is a statutory appeal.
My lord.
So therefore, this is not a 226. In a statutory appeal, we have a bit more authority. So we'll have to take up the 2 issues. We asked for an answer. The first was factual. The second was to what extent would they get the benefit of that 1 crore. If it was a year, turnover increased to 4, 5, 8 crore. But till it crossed 1, they would get the benefit. That is one. Whether intent to evade, that is the second one. And the third one pertains to that the brand. So,
my lord, the turnover and brand are interconnected in the sense, my lord.
no, it is not really, because on reading the order, it appears that just because it's a brand, they will not be entitled to the benefit. Therefore, it's not worthy of. But
in my humble submission, there is a fallacy. In fact, the tribunal should have said that since they've crossed the limit, my lord, the brand thing becomes irrelevant, my lord. I think that would be the correct logical thing, my lord.
But till they cross the thing, they would be entitled to that benefit.
My lord. So that's
they have
one.
to undertake that exercise.
My lord, that's one aspect, my lord. And the second aspect of evasion, the intention to evade, my lord, that again is connected with the fact whether they were in fact entitled to exemption under the northeastern policies, my lord. Now for
that is, where is the situation of the manufacturing facility?
My lord, for that, my lord, there are several criteria. This is what tribunal has said, that this is a conditional exemption, my lord, and they have to fulfill several conditions for that. One of the requirement is that plant and machinery should be new.
Sorry?
The plant and machinery should be a new plant and machinery, my lord. It cannot be second-hand plant and machinery, because many times people, the idea was to encourage industrialization on the basis of new plant and machinery, my
So
lord.
where is the finding that this is second hand?
Well, that is one aspect. Second aspect, it must be within the geographical location, should be within the notified
There's also no
limits, my lord.
finding on that.
Well, the tribunal has said, my lord, this plea was never taken by them even before the adjudicating authority or in the first round of litigation before the tribunal, my lord. And this was an afterthought, a new plea
So
taken at that
therefore,
level.
rightly or wrongly, that was part of our order. You could have carried that order and had that part set aside. Not having done so, that becomes binding on you. We are entitled to make our mistake and you are entitled to have it corrected. But not having had it corrected, it becomes binding on you. You cannot sit in judgment over that.
My lord.
After all, we are the appellate authority.
My lord.
So that you have to assess. Merely because it is no longer open to you. You have to do it because we have erroneously, let us assume we have erroneously directed. So that exercise has to be undertaken.
But my lord, in my humble submission,
Instead of
geographical location is only one aspect of the matter, my lord.
maybe there were 10 conditions.
10 conditions, my lord.
All
So the-
conditions have to be fulfilled.
My lord.
Even if one condition is not fulfilled, then they are not eligible. So instead of playing yo-yo, you do it de novo. We'll confine ourselves to the 3 issues. If you're ready, we'll proceed now. Because we don't want to be doing this,
Sending it back again.
we are sending it back again, and you sent it back, they have not done it even as you are aware,
My lord.
even under 226. Once we send it back, if they don't do it, then we can assume their authority and issue mandamus.
My lord.
We've done it over here. We've sent it back, it's not considered the 3 points, and it was a very, very pointed remand. It's not an open remand.
It was
If
pointed.
3 issues are
Three
filled,
issues.
and then you decide on these 3 issues.
My lord.
And you can't sit in judgment over that.
So, my lord, as far as the first 2 issues, my lord, in my humble submission, though there may be some error in logical reasoning, my lord, but I submitted, my lord, with your lordships, that the second point, that since they cross the turnover limit, my lord, the brand loses its significance, my lord. So those 2 issues in my humble submission have been addressed by the tribunal, my lord. Only the third issue remains whether it is revenue neutral or not, on the ground that they were entitled to refund of duty paid, my lord. And because it was revenue neutral, my
If it
lord,
was revenue neutral, then
there was no intention
to
to
evade would not be there.
my lord. My lord, this is, in my humble submission, that is only a real that requires an examination by your lordships, my lord. So, my lord, if I may pray, sometime, my lord, maybe.
That's why we had adjourned it last time. He was ready to go. You have to make up for what the tribunal has not done. We'll have to do the tribunal's work. The principal contention of the appellants in these 3 matters arising out of a common order is that despite a specific order of remand passed by this court, identifying the 3 issues to be adjudicated in this court's order of February 8, 2022, the Customs, Excise and Service Tax Appellate Tribunal failed to address the relevant issues. Full stop. On behalf of the department, it is submitted that the 3 issues pertain to the extended period of limitation, the eligibility to be regarded as a small scale industry because of a brand being manufactured and the eligibility to obtain any concession because of the quantum of turnover. Full stop. As to the first aspect, comma, the department says that there were several conditions that had to be met for the assessee in this case to have been entitled to refund under the previous regime, and it does not appear that all relevant conditions were satisfied in such regard. Full stop. On the brand issue, comma, the department submits that once the turnover crossed the minimum threshold, comma, as to whether there was a brand involved or not would no longer be relevant. Full stop. Paragraph, however, comma, all three aspects required due consideration and the order impugned dated August 25, 2022 does not appear to have covered all the issues, and comma, indeed, comma, on one of the aspects, comma, the order indicates that no dispute in such regard had ever been raised, even while the order in original was passed. Full stop. Paragraph. The easiest thing to do in the circumstances, comma, would be to send the matter back for a further fresh consideration on the three issues identified in the order of February 8, 2022, semicolon, but that would result in serious prejudice to the assessee and the persons in control thereof. Full stop. In particular, comma, it must be observed that when the appellate authority remands a matter for consideration on particular issues, comma, the inferior forum is duty bound to consider such issues and not ignore any one issue because it is of the opinion that such issue had not been raised earlier. Full stop. In such a scenario, comma, the only course of correction would be to challenge the appellate order and have the relevant issue annulled before the matter is considered on remand. Full stop. Paragraph. Upon the department not challenging the order of this court of February 2022, comma, the tribunal was duty bound to adjudicate on all three issues and render its opinion on all three issues. Full stop. Paragraph. Since the department seeks some time, to assist the court as the court intends to complete the exercise at this stage without the matter being sent back on remand all over again, let these 3 appeals appear 4 weeks hence, full stop, paragraph. It is made clear that no coercive action based on the decision of the tribunal, impugned decision of the tribunal, should be taken against either the SSC or the officers or persons
Directors.
in control thereof. Till disposal of these appeals. Yes, give a particular date.
Item number 5.
Specific date.
Yes.
May we please, Your Lordship? Your Lordship, I beg to seek an adjournment since the conducting counsel on personal difficulties. Your Lordship is unable
Sorry?
to attend. Your Lordship, I beg to seek 3 weeks adjournment. Your Lordship, since the conducting counsel, due to some personal difficulties, is unable to attend. Your Lordship.
On what ground?
Actually, Your Lordship, his sugar is quite high, 483. Your Lordship.
Since an adjournment is sought on the ground of arguing counsel being indisposed, let the matter stand over for 3 weeks as requested.
Highly obliged, Your Lordship. Good day.